Let's also briefly consider the European Convention on International Commercial Arbitration. The European Convention entered into force in 1964. It has some 31 contracting parties, including most European states other than the United Kingdom, Netherlands, and Finland, as well as 10 non-EU states, such as Russia, Cuba, and Burkina Faso. The convention has had a modest impact on the practice of international arbitration. The European Convention has had a relatively modest practical impact on international commercial arbitration. That's because the limited number of states party to it and because of the fact that virtually all of those states are also parties to the New York Convention. The European Convention addresses three main topics. It addresses international arbitration agreements, arbitral procedures, and the recognition and enforcement of arbitral awards. With respect to international arbitration agreements, there's no direct parallel to Articles 2.1 and 2.3 of the New York Convention requiring contracting states to recognize arbitration agreements and refer parties to arbitration. Nonetheless, the provisions of the European Convention in Article 5 in particular expressly confirm the arbitrator's so-called competence, their authority to decide jurisdictional disputes, including challenges to their own jurisdiction, as well as the authority of national courts to consider those jurisdictional objections. We'll consider these topics of competence, and the allocation of jurisdictional authority in greater detail in subsequent chapters. Article 5 of the Convention and Article 6 of the Convention address other aspects of the recognition and enforcement of international arbitration agreements as well. They address the choice of law governing arbitration agreements, a topic which we will also consider in greater detail in subsequent chapters. The European Convention also contains provisions similar to those of the Panama Convention, dealing with the arbitral procedures as distinguished from the arbitration agreement and the arbitral award. The provisions of the European Convention guarantee the parties' procedural autonomy on the one hand and the arbitral tribunal's procedural discretion on the other hand. We can see examples of the types of provisions contained in the European Convention addressing the arbitral proceedings themselves on the current slide. This includes provisions dealing with who may be designated as arbitrators, foreign nationals in particular, the parties' freedom to select the substantive law applicable in the arbitration in Article 7 of the European Convention, and the parties' freedom to agree either to ad hoc arbitration or arbitration conducted pursuant to institutional arbitration rules. The European Convention also addresses the recognition and enforcement of foreign arbitral awards. It does so, however, in a much more limited fashion than the New York Convention. The European Convention essentially supplements the general requirements imposed by the New York Convention that states recognize and enforce foreign arbitral awards. The European Convention does not repeat this obligation, but instead deals with one specific category of foreign arbitral awards, namely arbitral awards that have been annulled in the arbitral seat. We can see the provisions of the European Convention requiring recognition of annulled awards in some circumstances on the current slide. In some, these various conventions play a vital role in the international arbitral process. That is particularly true of the New York Convention. The New York Convention imposes broad but vitally important mandatory international law requirements on essentially all states in the world, 160 contracting states around the world. The Convention requires those states to recognize and enforce international arbitration agreements. In doing so, it gives those agreements an enforceability premium not enjoyed by either forum selection clauses or any other type of contract. The New York Convention also requires all contracting states, all 160 contracting states, to recognize and enforce foreign arbitral awards, subject only to limited exceptions. Again, the Convention gives international arbitral awards an enforceability premium not enjoyed in virtually any circumstances by national court judgments. National courts, as we will see, faithfully enforced and implemented the terms of the New York Convention, ensuring that the Convention provides a robust pro-enforcement legal framework for international arbitration. That legal framework has been essential to the development and popularity as well as the success of international commercial arbitration. Let's turn to the second layer in the international legal framework for international commercial arbitration. This layer involves national arbitration legislation and the national court decisions interpreting that legislation. National arbitration legislation accomplishes several objectives. First, national arbitration statutes enacted in virtually all states around the world implement the New York Convention and its requirements that states recognize and enforce international arbitration agreements and arbitral awards. National arbitration legislation provides the legislative basis for national court decisions applying the New York Convention and recognizing both international arbitration agreements and arbitral awards. At the same time, national arbitration legislation also provides a legislative framework for the conduct of international arbitral proceedings, regulating in greater detail, with more specificity and more comprehensively, different countries' arbitration legislation deals with international commercial arbitration. First, civil law jurisdictions historically regulated international arbitration, dealt with arbitration generally as a chapter within the National Code of Civil Procedure. That continues to be the case in a number of civil law jurisdictions, particularly in Europe: Germany, France, Italy, the Netherlands, Belgium, Austria. The German Zivilprozessordnung, the ZPO, contains the German arbitration law, the local German enactment of the UNCITRAL model law on international commercial arbitration. The French Code of Civil Procedure contains within it a chapter, Articles 1442 through 1527, that deals specifically with the arbitral process as one part of the broader Code of Civil Procedure. Common law jurisdictions historically took a different approach. Historically, in common law jurisdictions, separate legislation was enacted dealing specifically and only with arbitration. In the United States, for example, the Federal Arbitration Act was a standalone statute enacted by Congress in 1925, dealing specifically and only with arbitration. The same is true in England. The English Arbitration Act of 1996 and its various predecessor acts dealt only with arbitration and indeed, in some cases, international arbitration. Other common law jurisdictions, Singapore, Australia, Canada, were similar. Some civil law jurisdictions have more recently followed the common law model. A number of civil law jurisdictions, Brazil, China, Japan, have followed the UNCITRAL model laws model and enacted a standalone international commercial arbitration statute based on the model law. All of these models of international commercial arbitration legislation implement the New York Convention and provide the legal framework within which international commercial arbitrations can be conducted. More recently, the popularity of the UNCITRAL model law has made standalone national arbitration legislation dealing with international commercial arbitration more popular. We can see examples on the current slide of both common law and civil law jurisdictions from around the world which have adopted the UNCITRAL model law and its model of a standalone national arbitration statute. Most national arbitration statutes deal specifically and only with international commercial arbitration. That is based on the UNCITRAL model law, which, as we have seen, is limited to international commercial arbitration. Most national arbitration legislation, even in jurisdictions that do not adopt the UNCITRAL model law, follow the same approach. There are separate statutes dealing, on the one hand, with international arbitration and, on the other hand, with domestic arbitration. A few states, England, Germany, Argentina, Spain, deal with both domestic and international arbitration in a single statute. The same statute regulates both international arbitration and domestic arbitration. This approach is a minority position. Most states have enacted legislation that deals separately, on the one hand, with international arbitration and, on the other hand, domestic arbitration. There are two general categories into which national arbitration statutes dealing with international commercial arbitration can be divided. First, there are national arbitration statutes in most developed jurisdictions and most other jurisdictions around the world that is supportive of the international arbitral process, that facilitates the process. And second, there are a very few states, where national arbitration legislation does not facilitate, but instead obstructs and often frustrates the international arbitral process. We'll consider each of these two categories. Most states around the world, the vast majority of states, have adopted legislation that is supportive of the international arbitral process. The vast majority of developed jurisdictions in Europe, the Americas, Asia, elsewhere, have adopted supportive national arbitration legislation. Over time, these states have progressively refined their national arbitration statutes, adopting reforms, all aimed at facilitating the international arbitral process, all aimed at providing robust and effective support for the arbitral process. Over the past 40 years, virtually every developed jurisdiction in the world has adopted new arbitration legislation dealing with international commercial arbitration, or alternatively has amended its national arbitration legislation in line with reforms and developments in other jurisdictions. National arbitration legislation that is supportive of the arbitral process accomplishes a number of distinct objectives similar to those of the New York Convention. We can summarize those objectives as follows. First, national arbitration legislation affirms the freedom, the autonomy of parties to enter into valid and binding agreements to arbitrate future disputes and imposes obligations on national courts to recognize those agreements and their material terms. Second, national arbitration legislation provides mechanisms for enforcing international arbitration agreements, in particular by referring the parties to arbitration, either through a stay of litigation in national courts or alternatively the dismissal of litigation on the merits of the parties' disputes in national courts. Third, most supportive national arbitration regimes prescribe procedures for confirming arbitral awards and, in a very limited number of circumstances, either denying confirmation of arbitral awards or annulling or setting aside those arbitral awards in the arbitral seat. Fourth, supportive national arbitration legislation also requires the recognition and enforcement of foreign arbitral awards, subject only to very limited exceptions. Taken together, these various objectives implement the New York Convention. The requirements to recognize and enforce arbitration agreements, including by referring the parties to arbitration in national arbitration statutes, implements Article 2 of the New York Convention. The requirements to recognize and enforce foreign arbitral awards implements Articles 3, 4, and 5 of the Convention. In addition to fulfilling these various objectives, supportive national arbitration legislation does a number of other things. In particular, national arbitration legislation typically limits the powers of national courts to intervene in ongoing international arbitral proceedings, a principle of so-called judicial non-interference. National arbitration legislation also provides for specified, but very limited, judicial assistance to the international arbitral process, most importantly, in the context of constituting the arbitral tribunal, selecting the arbitrators, and, as a default rule, hearing challenges to the arbitrators if the parties have not agreed upon any other challenge mechanism. National arbitration legislation also affirms the parties' procedural autonomy to agree upon the procedures to be used in their arbitration, as well as, in the absence of such procedural agreements, the arbitral tribunal's procedural discretion, in both cases subject to very limited mandatory rules of fairness, procedural regularity, and due process. Some national arbitration legislation provides for other types of judicial assistance, such as assistance to the arbitral tribunal in taking evidence or granting provisional measures in limited circumstances in aid of arbitration. Most national arbitration legislation also affirms the parties' autonomy to select the substantive law governing their dispute and the arbitral tribunal's authority, in the absence of a choice of law agreement, to select the law governing the parties' dispute. All of these various provisions of national arbitration legislation serve one overarching goal. That goal is to ensure that international arbitration can be used efficiently and effectively to resolve international commercial disputes, for the purpose of encouraging international trade and investment, for the purpose of reducing those particular risks to which international trade and investment are subject, the risks of cross-border transactions. Let's look in a little more detail at some of the principal national arbitration statutes that are used today. The most important by far is the UNCITRAL Model Law on International Commercial Arbitration. That law is arguably the single most important statutory instrument in the field of international commercial arbitration. The model law was preceded by very extensive consultations between states, business, and international arbitration communities and regional organizations. That consultation produced a draft prepared by UNCITRAL, the United Nations Commission on International Trade Law, which was ultimately adopted and then presented to the General Assembly of the United Nations, where in turn it was adopted by resolution in 1985. The original UNCITRAL model law in 1985 was designed to be, like other UNCITRAL model laws, implemented by national parliaments. Standing alone, the UNCITRAL model law, like other UNCITRAL model laws, has no independent legal force. The resolution of the United Nations General Assembly approving the UNCITRAL model law on international commercial arbitration did not give that law any independent legal status. The law does not have the independent status of international law. Instead, in order for the UNCITRAL model law to have legal force, it must be adopted in individual jurisdictions. It must be implemented, for example, in Germany or Austria or Singapore. Until the UNCITRAL model law is adopted as local legislation, until it provides the basis for a local statute, the law in and of itself has no legal force. It is only the adoption by a national parliament of a national statute based upon the model law that give the model law's provisions any legal effect. The UNCITRAL model law aims at harmonizing the treatment of international commercial arbitration in jurisdictions around the world. It also aims at ensuring the effective and faithful implementation of the New York Convention, and it does so, ensuring that the provisions regarding international arbitration agreements in Article 2 and the provisions regarding international arbitral awards in Articles 3, 4, and 5 are faithfully implemented. The model law has been adopted in a substantial number of jurisdictions around the world, some 60 sovereign states and some 100 jurisdictions in total if one includes provinces and states in federal systems. Many other states have used the UNCITRAL model law as a model for arbitration legislation that was adopted locally. The English Arbitration Act, for example, although not an implementation of the UNCITRAL model law, drew heavily on a number of aspects of the model law. Like the New York Convention, the UNCITRAL model law is relatively short, relatively concise. It contains only 36 articles, which together deal comprehensively with the entire international arbitral process. Let's consider briefly, and by way of introduction, what the various provisions of the model law do. Articles 1.1, 1.2, and 1.3 address the scope of the model law. We've considered them previously. They provide that the model law applies to international commercial arbitration. We've considered the definitions of those various terms previously, but they limit both the scope of this webinar series and the scope of the UNCITRAL model law, which, as its title, as well as Article 1, provides, is limited to international commercial arbitration. Likewise, the model law is limited on the basis of territoriality to arbitrations that are seated within a particular model law jurisdiction. Put differently, most provisions of the model law have only territorial application. They apply only to arbitrations that are seated within the territory of the state in question. Put concretely, if an arbitration is seated in State A, it will be subject to the national arbitration legislation in State A, including the UNCITRAL model law as adopted in State A. That arbitration, seated in State A, will not be subject to the national arbitration legislation in States B or C or D. Article 5 of the UNCITRAL model law states a principle of judicial non-intervention in the arbitral proceedings. Except where specifically provided for by the UNCITRAL model law, the arbitration is left to the parties and to the arbitrators. National courts play no role in the arbitral process while it unfolds. That is the principle of judicial non-intervention, recognized expressly in Article 5 of the UNCITRAL model law. Article 6 of the model law identifies a court in the arbitral seat, the place of arbitration, which has so-called supervisory jurisdiction over the arbitral process. By virtue of Article 5, however, this supervisory jurisdiction is extremely limited. National courts play only a very limited role at very specific points in the arbitral process. We will consider those points in greater detail throughout the remainder of this webinar series, but they're limited in principle to jurisdictional disputes at the outset of the arbitration, to the constitution of the arbitral tribunal, and then only in limited circumstances to taking evidence in aid of the arbitral process and occasionally granting provisional measures or considering applications for provisional measures, again, in aid of the arbitral process. Apart from these very limited circumstances for judicial intervention, the only role for national courts is then at the end of the arbitral process, either to consider applications to annul the award or alternatively to recognize and enforce arbitral awards. Article 6 specifies the national courts, which will perform these very limited supervisory functions. Articles 7 through 9 of the model law implement Article 2 of the New York Convention. These provisions provide for the recognition and enforcement of international arbitration agreements. They provide that disputes subject to international arbitration agreements will be referred to arbitration rather than resolved in national courts. And they define the so-called writing requirement, the requirement for a written form for international arbitration agreements. Again, we will consider all of these aspects of the model law in greater detail in subsequent chapters.